but also to put the spotlight on the parts of Hollywood they have dedicated their careers to being the antithesis of. That was one sentence. Okay, I've got it right here. This is the amended complaint filed by Justin Baldoni against Blake Lively, Ryan Reynolds, and everybody else. Let's take a look. I'm an entertainment attorney. I demystify legal issues facing artists, athletes, and creators in the entertainment world. If you're interested to hear more about entertainment law, follow along. The following is not a story the Wayfarer parties ever wished to tell. Unfortunately, Blake Lively has unequivocally left them with no choice, not only to set the record straight in response to Lively's accusations and the New York Times company's maliciously and recklessly propagated falsehoods. Okay, what on earth am I looking at? There is way too much to go into in just one video, so I'm just going to talk about one thing. This amended complaint has 391 numbered paragraphs. Is that normal in a lawsuit? What's going on here? This document is about public opinion. A complaint in federal court needs to have three things: a short and plain statement saying this is the right court to file this lawsuit, a short and plain statement showing that the claimant is entitled to relief, and three, a demand for relief. For example, if you file a breach of contract action, all your complaint needs to say is, the court's jurisdiction is proper and here's why. I had a contract with the defendant that said this, defendant breached the contract by doing this, and I'm entitled to damages. That's all a complaint needs to say. Everything else comes out in trial. Your evidence supports the allegation in the complaints. The only reason why a 391 paragraph complaint would be filed, it's about shifting public opinion. Had Lively chosen to merely ride out the self-inflicted press catastrophe she faced in August 2024, the public would likely have moved on and never known the truth about her. They would have never known that she deliberately and systematically robbed Justin Baldoni and Wayfarer Studios LLC of their movie. No one except the parties involved would have known that she used threats of extortion to relegate the colleagues she once highly praised to a basement to sit out their own premiere, while she enjoyed the spotlight of a premiere and after party that was ultimately co-financed by both Wayfarer and Sony. She would have gotten away with these things and more if it weren't for those meddling kids. It reads like some sort of tabloid novel, and that's because that's what it is. It's filled with screenshots of text messages, photos, timestamps. The only reason to do this is because you want people to see it. The causes of action are civil extortion, defamation, false light, invasion of privacy, intentional interference of contractual relationships, negligent interference with contractual relationships, and intentional interference with prospective economic advantage. I'm happy to go into the legal elements of each of these claims if you want to, comment down below, but if something is filled with flowery language like this, there's a reason for it. They're trying to control the narrative. Who's right, who's wrong, I don't know. It's always important to remember that complaints are allegations. Allegations don't really mean anything until a judge or jury says they do. I'm happy to dive deeper into this thing, and I'm happy to dive into Blake Lively's claims as well. Let me know if you want me to.